That's okay. I think I had gotten to the stage of copyright reform with Mr. Wilson. So, Mr. Wilson, as you said, you alluded to that you had made a submission to this committee, not the estimates one, in the inquiry on copyright amendment online infringement bill. Unfortunately, I think at the time it might have only been Senator O'Sullivan and I that were participating, although there is much broader interest in that matter. You said in your submission that Australian copyright law was in the need of serious reform. Would you care to elaborate on what reform is needed?
Well, the principal focus of my submission, Senator, was to talk about the broad need for some sort of contemporary and relevant expanded fair dealing provision operating the Copyright Act or some sort of fair use provision. As I'm sure you'll appreciate, there is a tension between free speech and the property rights that exists in intellectual property, including copyright. The Copyright Act was drafted in the 60s. It has had a series of amendments since. Technology clearly has contributed to rapid development and tested the boundaries of the Copyright Act. And so my general proposition is that the Act should be reformed to reflect the challenges presented from technology, at least because of the rate of the speed of technological innovation, so that the Copyright Act can meet the expectations. But as a broader sort of, I guess you'd almost say, philosophical principle, laws should always reflect practice, I think, in general, and the consent of the public. And one of the things that concerns me greatly is making sure that there is not copyright infringement and that property rights are properly respected. The current provisions without some sort of expanded fair dealing or fair use provision, particularly for non-commercial purposes or where a royalty payment may otherwise be made, may be legitimising, in the eyes of some, copyright infringement, which I consider to be a very strong infringement on people's property rights.
So then the government's failure to act on the fair use principle is a significant concern for you?
Well, Senator, the Australian Law Reform Commission released a report, if I'm not mistaken, mid-last year, looking at the...
No, it's November 2013.
There you go, November 2013. Apologies, Senator. But it has been around for some time, that is correct. I understand the government's had other issues they wish to address. I think this has been something that has been abundantly clear for a reasonable period of time. I know the last major effort at reform of legislation, particularly with relation to platform shifting, occurred, I think, when Philip Ruddock was the Attorney-General. I can't remember the exact year. But these issues have been evolving over time, and I would hope that it is something that's addressed in the future. We need to be mindful that the Copyright Act is still in place, copyright is still broadly being respected, but I do think there is a case for reform around those issues of tension between free speech and property rights, but that is a matter for the government.
So the Law Reform Commission's report back in November 2013 dealt with the fair use issue?
It made two proposals. One was of a fair use provision, and in the absence of support for that, it was in some sort of expanded fair dealing provision that already exists within the Act. Since making my comments, Senator, at the committee appearance where both yourself and Senator O'Sullivan were present, I've had a number of people from different industry groups who've come and spoken to me, and without breaking confidences or going into the detail, they have raised concerns with the ALRC proposals, but not in the substantive nature, more in the nuance. And I think a proper consideration of these issues through political processes and the processes of the Parliament would be most welcome, and I would encourage and welcome that and be keen to contribute to that discussion.
Well, we're yet to report on that matter. Could I invite you to make a supplementary submission dealing with those issues rather than canvass them here and now for the benefit of our considerations?
Senator Collins, one of the great challenges we have within the Commission is constraint on resources, and as you'll note, the submission I made last time was a letter which covered some of the broad themes. Those cover the broad reflections I have about that specific bill, in particular with relation to copyright and the inclusion of an expanded fair dealing or a fair use provision with relation to site blocking, whereas something more substantive on copyright generally, I suspect, would be better left for another day when there is actually a bill that covers the issues of copyright more generally.
Oh, okay. So the discussions you've had with people subsequently to those hearings are on the broader fair use issue
Correct.
rather than the site blocking matter?
Correct.
Okay, I understand you there. Attorney, are we close to receiving a government response to the Law Reform Commission's report?
Well, let me tell you what the government's doing, Senator Collins. As you know, we are embarking on a very important reform to the law of copyright in relation to online piracy, and that legislation is before. Thank you. That legislation is before the Parliament at the moment. That will, among other things, include an amendment to the Copyright Act, which includes a much stronger power to obtain injunctive relief where there is facilitation of piracy. That's a matter of very great importance to the creative industries in particular, and I've said many times that they're entitled to the fruits of their labour like anyone else, and their capacity to be fully remunerated for the fruits of their labour is being very significantly eroded by piracy of their audio and visual product. So that is the particular area of law reform on which the government is embarked just at the moment, and we hope to have that legislation through the Parliament before Parliament rises for the winter recess. Now, then there is the broader issue opened by the Law Reform Commission, which Mr Wilson has just addressed, of the desirability of a comprehensive reform of the Copyright Act. And it's right, I mean, it's a commonplace observation to make that the Copyright Act in its current form is an act of 1968 when John Gorton was the Prime Minister, and there are many who are of the view, and I am one of them, that the time is upon us for a comprehensive review of the Copyright Act. And I've just been reading actually Sir Richard Arnold's Herschel Smith Intellectual Property Lecture given in London last year, in which he relates the various reviews and reports and reforms to the UK Copyright Act in the last several decades. And the point that Sir Richard Arnold makes, with which I agree, is that of course copyright law needs to be kept up to pace with the speed of technological change. So the day is upon us, I think, Senator, when we do need a comprehensive root and branch reform of the Copyright Act. But that is not the work of, a few months. That is a major piece of law reform, and when the government has an announcement to make, we will make that announcement, but we're not going to be making the announcement in Senate estimates. In relation to the Law Reform Commission report, I have been on the public record as saying, and Mr Wilson and I have a slight difference of view about this. I'm not persuaded about a general fair use exemption. I think Mr Wilson has correctly stated the two principal values in tension here between the protection of intellectual property rights and the protection of freedom of speech. And from a philosophical point of view, the key task here is to find the right reconciliation between those two potentially inconsistent values in this policy area. But as I say, I'm not persuaded, and this is not the first time I've said this publicly, as to the desirability of a general fair use exemption. Now, beyond that, there's really not a lot more I want to say to you, Senator Collins. We have the particular and important measure of law reform before the Parliament at the moment. You've heard what I have had to say about a more comprehensive rewrite of the Act, and we'll have something more to say about that in the future.
Attorney, are you aware of some of the criticism put to the committee? Sorry, I can't. Are you aware of some of the concerns put to the committee that acting on the site blocking issue without comprehensive reform is piecemeal and that other measures should be occurring at the same time?
Well, piecemeal is a pejorative. You could describe the same thing as targeted. The advice from my department and my officials, including Mr Fredericks, who's a very, if I may say so, erudite and articulate about these matters, we actually did have a discussion about whether or not it was best to go with this targeted area of law reform in relation to an acute issue now, rather than bundle it up as part of a long rewrite of the Act. And we made the judgment, which I've got no doubt was the right judgment, that we should deal with the urgent matter by a targeted piece of law reform now. And of course, we are mindful of the fact that the current Copyright Act is not far off its 50th anniversary.
But I am correct in understanding from what you've said that it is time for more comprehensive review.
I think it's been time for a while, as a matter of fact, Senator Collins.
But it was in the context of my question about a Law Reform Commission report that dates back to November 2013 now.
Yeah, but Senator Collins, as I was at pains to point out, the main recommendation of the Law Reform Commission's report is not one that I'm disposed to agree with. So Law Reform Commission reports are very interesting and illuminating, but they don't necessarily point the direction of they're not the only way to reform a statute.
No, I understand that, but a government response and alternative direction would be helpful to understand as well. So I look forward to the announcement that you've indicated you don't wish to foreshadow in this hearing.
Well, I'm not going to be making any announcements, but, you know, we all know, everybody in this industry, everybody who takes an interest in this area of policy, I think would agree that the time is upon us for the sort of comprehensive look at the Copyright Act that has been undertaken in recent years by the British government. Yes,
I think there's no question from what we're hearing also the very strong view that time is upon us. I take on... Sorry.
Well, I mean, just to put it in context, the British Copyright Act in its current form owes its genesis to an Act of 1911, which was replaced by an Act of 1956, which was replaced by an Act of 1988, and the 1988 Act has been the subject of a multiplicity of inquiries since. The Gowers Review, the Hargraves Review, various others as well. So this is a much debated policy space, but we do need that debate to bear fruit in comprehensive law reform.